Let's start in Wisconsin, famous for cheese, beer, and broadcasting strange trials. Darrell Brooks continues life behind bars where nobody tells him what to do except every single thing that he does. His remaining trial case, the one involving Erica, that's got some pretrial litigation going on, and his parade attack appeal remains at the starting gate. His appeal attorney has requested another extension before filing something on the matter. Now, he might file a notice of appeal or post-conviction relief, and that starts this whole process. Or he might file a notice that he's going to file a no merit report, which would mean he doesn't see a good faith basis for appeal. The no merit is not something he needs to file if he thinks the appeal, say, is fairly weak. It means what it says, no merit. There are various losing grounds that could be the basis for an appeal. I could write up a brief on jury selection, self-representation, competency, errors at trial, etc., and at least try to make a good faith argument that they be considered. But I don't think they're winners. At any rate, the no merit would be the attorney's position that he can't file an appeal that he thinks has a chance of winning. And I still think that's what's coming, but we'll see. If the attorney feels that way and discusses it with Brooks, Brooks could simply forego the appeal. Yeah, that seems unlikely. Brooks could go ahead and try to fire the attorney. But what seems more likely is the attorney would need to file the no merit report, and the court would consider that. If the court agrees, Brooks can still proceed with an appeal, but he'd need to do it himself, pro se, pro per, whatever, or hire his own attorney at his own cost. The current attorney would be off the case. If the court disagrees, it could ask the attorney to reconsider or appoint another attorney, but that's unlikely. So we'll see what happens, but whatever it is, it won't be fast. Staying in the state, let's hit the Nicolae Mui case. Hey, clear video of the incident, so everyone must quickly and clearly agree on the correct result, right? Wrong. Many thought it was a clear case of self-defense. I get it. Many thought it was instigated by Mui, and he could have retreated and avoided all of it. From what I saw, most opinions were formed without knowing the Wisconsin law on the subject, which is more complicated than you think. Basically, you don't have a general duty to retreat, but the jury can consider whether you could in determining whether your use of force was reasonable. If you instigate a fight, then you do have a duty to retreat. But if you do retreat and withdraw from the fight and are re-engaged, then that duty to retreat is gone. In any of these cases, the idea is that you were in reasonable fear of death or serious bodily harm and used the deadly force to counter that. In any of these cases, in Wisconsin, if the issue of self-defense is presented, the burden is on the state to prove beyond a reasonable doubt that you did not act in self-defense. Not like that everywhere. That's interesting and blown over, I think, by many, maybe even some on the jury. In any event, I think you could watch that video and conclude that, hey, Mui was touched first, and he only initially touched a female to stop her from touching him. And then he suffered a serious, dangerous attack by multiple people. He responded by stabbing. That's all he could do to defend himself. And then when he could, he left the scene. You could also watch that video and conclude, hey, Mui instigated the situation by running up on the young man, grabbing an inner tube, and didn't explain himself. Then he strikes a female who only had her hand on him. And then from that time that he instigated the confrontation, he had opportunities to leave. But instead, he stood around and wandered around, tried to wave people from his group over, and took his knife out and unfolded it before any of the males ever made contact with him. You could also fail to realize a chaotic situation like this can be viewed more than one way and rage out at anyone who has a different opinion. That seems popular, too. But from the one juror comment I heard, it appears the juror believed Mui could have left and did not. They said there was no fence around him, meaning they either thought he instigated the situation or they thought his avenues of retreat made his use of force unreasonable. Talking about the juror's perspective, not mine. My personal take is I don't think there was a sober person in the bunch. Mui shouldn't have run up on another group and grabbed their inner tube. I mean, if somebody did that, well, I'm taping my friends and saying it was my wife's inner tube, but we're on high alert at that situation, right? I mean, that's bizarre. However, that group shouldn't have reacted like a pack of feral hyenas, amping up the situation, lying about the guy screaming, trying to make it worse than it was. And the women shouldn't have entered the situation, the scene, and placed their hands on Mui. They had no right to do that. And Mui should not have been attacked and knocked down in the water, struck in the head, and attacked from different angles. At that point, I think it is reasonable that he employs a weapon to defend himself. It's just down really to whether the legal defense is there based on what happened before that. Now, I don't think anybody planned to stab or get stabbed that day, that's for sure. It shows just how fast the situation can go downhill and how the bad judgment of everyone leads to a situation where there are no winners. If Mui had acted differently, things would have turned out differently. But if all the screaming kids had acted differently, things would have turned out differently too, and their friend wouldn't be dead. I've personally found the state witnesses to lack credibility, with their newfound clarity about Mui punching someone. But then Mui testified, and he seemed to be the biggest liar of all, intending to hide evidence and deceive about his acts from the very start. And I think that continued on the stand. If you do decide to talk to the police, it's your choice. Lying about material facts, it better work out the first time, because if not, you're going to have a lack of credibility later. And that impacted him, I think, according to the jury. Now, I can definitely understand the feeling this was self-defense. When he was attacked and knocked down, he was, in my opinion, in great danger. They weren't letting him go. They were hitting him, surrounding him, screaming at him. And he's in the water. He's on rocks. He could be seriously injured or killed at any moment. But legally, that's not the whole story. And it wasn't the whole story for the jury either. You know, if it's possible, obviously avoid these types of encounters. You might pay even when you think you were defending yourself. And if you're on the other side of it, you don't get unshot or unstabbed or undead just because charges are filed on the other guy. No winners. Let's take it to Idaho on another major case, Bryan Kohberger. He's filed his alibi, and that has stirred up some comments, and let's break it down. Like many states, Idaho says if you want to use an alibi as a defense, you need, if requested, to provide what it is and who and what evidence supports it. If you don't, then this evidence might be excluded from trial. An important point is accepted from this is the defendant himself. He doesn't have to say anything right now, and he could, if he chose, come to trial and testify about his whereabouts at that point. He's exempted from the statute personally. Now, in this case, Kohberger's alibi came in for some ridicule due to the narrative about being out driving at night to see the stars and the moon. Okay, well, he's a poet, and he didn't know it. By itself, that sounds like a lousy alibi, right? It's not much to it, if it's even an alibi. But the more interesting and really only material part, I think, of the filing was that the defense support for this would be by expert witness involving cell phone data. As far as the purported alibi goes, if the evidence shows the phone was traveling somewhere away from the crime scene at the time of the crime, hey, now that's going to be great for the defense, right? Maybe enough for the defense. Now, of course, the defense can dispute the state's contentions about cell phone evidence, even in the absence of an alibi. They can try and show the location conclusions that the state reaches are not supported by the evidence. But here, they're going to go beyond that, they say, and show the phone was actually somewhere else. Notice, though, they say that, hey, if the evidence isn't there for the early morning locations to show that, then it's the state's fault. That's not a throwaway sentence. On the defense side, it can mean incomplete discovery by the state, which would be concerning. But on the state side, it can be that if the phone was turned off, the data requested, whatever it might have shown, it doesn't exist. And they have said it was turned off at least during some material times of this crime. We're going to find out if that's true and whether there's any kind of data that supports what the defense has to say, because it's obviously a crux issue, I think. Now, the state has important evidence in the form of the trace DNA. Don't even try and tell me it doesn't matter. That's confirmation bias. The defense certainly will contest the weight of this evidence, including various ways trace DNA might have been introduced on the sheath or processing analysis issues. But the weight will be for the jury. Sure, it's a valid point that trace DNA could have been introduced from a source other than Kohberger directly. Absolutely. But if it had his fingerprint and a full DNA profile on that sheath, that could be contested as well. I mean, maybe he sold the knife to someone before the attack, handled someone else's knife, and that's what it was, had the knife stolen or whatever. Any of this could be contested. Those are arguments on weight. And if you want to diminish the weight, it's important to have a plausible, perhaps likely scenario on why, rather than just a hypothetical situation of how something could have happened. You can bet his defense team is taking this evidence very seriously, regardless of what social media says. On the counter side, from what we've seen in filings, it appears no forensic evidence was obtained from Kohberger's car. That doesn't mean he didn't do the crime, but boy, it's a great point for the defense that in this condensed time frame, which is what the state's theory is, he wasn't there very long, Kohberger would have needed to get in the car pretty quickly and go, right? And if he did, where's the evidence, even trace evidence of the crime? Of course, the state's going to have to explain this, right? With the same caveats expressed above. They can't try this on social media. They're going to have to convince the jury why it's plausible there was no evidence in that car. Really, other than just having an opinion based on what's out there, it's not possible to know all the evidence in any direction in this case because almost all of it is covered by confidentiality provisions. Aside from filings, the rest is social media nonsense on both sides about how he looks guilty when he's sitting in court. He stalked the victims based on some nebulous and not state-endorsed theory of an Instagram account, or how the roommates did it, how it's impossible for him to have done it in that time frame, tunnels, all of the stupid things that are on the other side of the case. All right, let's leave out of there because waiting for more facts there. Let's go back to our head east to Indiana. Is this guy, Richard Allen, ever going to stand trial? Is he going to trial in May? He's supposed to. It might happen, but I wouldn't bet on it. There's still discovery going on. But if possible, it should. He's sitting in prison, not convicted of anything. Is that a satisfactory state for anybody? I mean, temporarily, yeah, but let's get this trial over with. A lot of this case is confidential, but I think we see the parameters. Allen's proximity to the kidnapping scene at the time of the event, and how unlikely it is, based on witness narrative, that it was someone else there. That's the state's case, right? The defense counter to that narrative is based on Allen's current statements of when he was there, as well as contentions about witness descriptions of the person on the bridge and the vehicle scene where Allen was purportedly parked. The .40 caliber round found at the scene, and whether the jury will believe that the extraction markings found on the round are distinctive enough to link that round to Allen's firearm. That's a big open question, right? The defense says, no, of course not. There's not going to be the science for that. It's not going to show that. The evidence not going to show that. And I have a feeling they're going to say, but you know what was there? Other material forensic evidence that isn't linked to Allen. Maybe they've got DNA from some other party or something like that. It's just a sense I have there. And the confessions. It seems clear at this point that Allen has said at various points, I did it. But it also appears that at least some of these statements, the ones that I've seen in filings, are factually at odds with the evidence at the scene. Will these amount to anything? An actual confession that the jury would consider? Or will they be seen as rantings from someone who suffered a mental break? I think the trial is going to be required to answer all this. Now, will the defense be able to point to anyone else specifically, the odious person or whatever? You don't get to just do that. There's a legal standard to meet before you point to a specific other person. See the current Karen Reed situation and even the Zachariah Anderson case. All right, staying in Indiana, let's talk about Dejaune Anderson. I don't really have to worry about pronouncing her name because she's just an entity. I call her the entity for short. She's out there talking about Space Force, a bunch of sovereign citizen nonsense, and she wants to represent herself and has started out with a load of written filings that would make Darrell Brooks green with envy. Her case might be one that highlights the slim space between competent to stand trial, which she appears to be, and being competent to represent oneself, which is a right. The judge will need to address both, I think, and he's ordered a competency hearing. Remember, being competent to represent oneself, it's not a test of knowledge of the law or making great decisions. I've gone over the test before. You have the right to be dumb. This is different than insanity at the time of the crime. That's an entirely different process and standard. I suspect more of her hearings will be televised, and they'll be interesting. I'd say she probably does suffer from a mental illness, but it's whether that issue rises to the level of incompetence. And you can be pretty whack and still beat the competence standard. Head down south to Florida. Check in on noted author and luggage misuser Sarah Boone. Her new attorney has been active in the case and has secured experts on Sarah's behalf. The trial's been put off and will be scheduled perhaps after the next status update. All we really know right now is that either Sarah's out of ink or this attorney has met Sarah's exacting standards of representation. Could this case at some point result in a plea? It may be, but so far it's still trial bound. In the Granite State of New Hampshire, Adam Montgomery will be headed to court, this time for sentencing. He's, of course, convicted of murdering his daughter, Harmony Montgomery. The judge has ordered him present, and for the sheriff to accomplish that, basically by using whatever means are necessary. I think many of us are hoping many means are necessary. But at any rate, the pictures of Harmony, his young little daughter, would melt, I think, anyone's heart. Anyone except, it seems, her own father. How awful is that? There's nothing that can be done to balance the scales for the horrors visited on Harmony and her sad end. But at the very least is he can be made to sit there while her existence and the tragic, inexcusable loss of her life are acknowledged in public. Another sad case has just occurred in Michigan where Marcella Chidester drove her car into a building, killing and injuring children and adults gathered for a birthday party. I'm sure you've seen this case. The restaurant she was at prior to this say they served her chili and a single glass of wine. Her attorney's pitching that she's not responsible because she had a seizure. But police say that she was well over the legal limit for alcohol. So we'll have to see what happens with that. She's charged with murder, and I'd say it's unlikely she's ever going to be free again. You know, driving a multi-thousand-pound vehicle capable of great speeds is, while it's routine, it's a great responsibility. And being drunk or being subject to a medical condition that can cause loss of control, or both, and then still driving, those are choices. Too many people still choose to drink and drive, in my opinion, and too many still consider it to be no big deal. Hey, it's not right when it works out, right? But you know what? You're putting other people at risk. And in my opinion, you need to pay when you're caught, and ideally caught before you hurt somebody, especially someone else. In Texas, the trial of rancher George Kelly for the shooting death of a trespasser and illegal border crosser on his property has ended in mistrial. A really sad situation. There were a lot of forensic issues in the case, as well as factual issues, and the jury ended hung with only one not willing to vote for an acquittal. The state could prosecute this case again because it's a mistrial. That seems unlikely, but I don't think they've committed either way. And let's wrap it up with at least a little bit of good news for the system, which so often malfunctions, and sometimes it accidentally works out a little bit. In Georgia, Ronnie J. Towns got some bad news. He's awaiting trial for the murder of a couple who were interested in purchasing a vintage Mustang, which he said he had. The murders happened all the way back in 2015. He still hasn't gone to trial yet. I mean, he was caught pretty quickly. Well, originally he fought his indictment. He got it dismissed, right? And we see that in a lot of cases, like this indictment's terrible, it's bad or whatever. But I don't think everyone realizes that when an indictment is dismissed due to the fact that it has some variance or whatever defect, it typically can be cured by the issuance of a new indictment. Double jeopardy has not attached at that point in the case, and a new indictment was issued against him. So now his case was delayed again during the virus panic. So he gets his indictment dismissed, a new one's issued, and then it's slowed down over this whole virus response. It's back on track, though, finally, and due to come to trial, but Q won for the good guys. All this delay actually worked for once for some good. This month, a magnet fisherman, they're not looking for steelhead trout or whatever, they're looking for stuff, found a rifle and then phones and credit cards and other items associated with victims of the crime with this magnet fishing pole thing, leading to a search warrant that apparently produced even more evidence at another house. So this guy was facing the death penalty before this fine, so the case must have been strong already. But you know what? For a scumbag like this, the more evidence against him, the merrier, in my opinion. All right, so that's a quick survey of the cases. I haven't done this show in a while because we have a lot of activity going on. And if, from the clips I'm showing, you see I'm not up in my office right now, which is largely cleaned out, down in the music room, which is also largely cleaned out because we are supposed to be relocating at some point. But before we did, we recorded some things to use. And so the intro music and the outro are evening musings that we have concocted here. And we will head into one of those now. Thanks for coming by. I'll talk to you later. Thanks. Bye.